All right, guys, Levi Trumbull reporting here. I did not think that this was a video I would have to make today. I'll just put that out there. I cannot even believe that I am making this video right now. But we, in fact, have an outcome of the hot air balloon lawsuit, the one that we first brought you a few days ago. As we last reported, the case of Susan Maharaj versus Smith Ballooning LLC was a massive, voluminous lawsuit filed in 2021 where the plaintiffs alleged that Smith Ballooning LLC was negligent in flying their hot air balloon over the plaintiff's house, and they also claimed that the noise, the volume of the hot air balloon being fired up on an adjacent property was so loud, obnoxious, and annoying that it gave rise to a negligence claim in court. Well, that was the allegation. We made a whole video about it. You can watch that if you'd like. But today, January 8th, was supposed to be the start of what was supposed to be a jury trial in the Circuit Court for Frederick County. Well, there was not a jury trial, and here's how today's proceedings in the Circuit Court for Frederick County went. We have right here a copy of the notes from the civil courtroom worksheet, and we're going to read you them right now. Case called for jury trial. Plaintiffs are present pro se. Now, why are they pro se? They're pro se because only about a week ago, the plaintiff's attorney filed a motion to withdraw and to postpone the case for the third time. Now, the case would ultimately not be postponed. However, the attorney in question was allowed to withdraw from the case. So when it says plaintiffs are present pro se, that is why. It says defendants were present with counsel. Plaintiff did an in-court motion to postpone to obtain new counsel. And as you can guess, that motion in court, that verbal motion, was denied. Plaintiff then elected not to proceed with a jury trial. Imagine that. The plaintiff elected not to proceed with the long-scheduled jury trial. I'm going to keep going. Defendant requested for final judgment in the favor of the defendants. That motion, that verbal motion, was granted. Case dismissed. Judgment in favor of defendants. Court to prepare order. How you like that? After 2.5 years of the most rigorous civil litigation I have ever seen, you have this? Really? You have the plaintiff showing up to court pro se and trying to postpone, which obviously they knew they were not going to get. But then the plaintiff elects in court not to proceed with a jury trial? Really? 2.5 years of the most intense litigation that I've ever seen. And this is how this case ends? Now, I want to be clear. This is why people hate the judicial system. Right here. It's stuff like this right here. For 2.5 years, this balloon company was essentially put through a legal nightmare. Tens of thousands of pages of documents. Hundreds and hundreds of pleadings on this record since 2021. One of the most voluminous cases maybe in Frederick County's history. And after 2.5 years, what's the end result? Well, we don't have our attorney with us, so I guess we'll just drop it. Okay. Wow. I want to briefly bring up two legal terms, and I want to define them real quick. The first one is going to be malicious prosecution. Malicious prosecution is the filing of a lawsuit for an improper purpose and without grounds or probable cause. The improper lawsuit may either be civil or criminal in nature. And the second definition that I want to give you is for the term vexatious litigation. Vexatious litigation is legal proceedings started with malice and without good cause. Vexatious litigation is meant to bother, embarrass, or cause legal expenses to the defendant. Now, I don't know if that was the intent of the plaintiff. We're not going to put anything like that out there. But it seems to me that whatever happened here is completely out of control. Completely. All right? You have to remember that there are actual people who were having to defend this case from the start, 2.5 years. And for what? For what? So that they can come to court on the day of the jury trial, the first day of what is supposed to be a 5-day jury trial, and hear the plaintiffs say on the record, oh, well, we need a motion to postpone, and when that's denied, oh, well, plaintiff elects not to proceed with the jury trial. Really? Really? If you're the defendants in this case, you have every right to be angry. And I hope that the defendants' balloon company had a liability insurance company which covered the costs of this proceeding. I would imagine that this man's insurance company, I presume he's a company, he's an LLC, I would presume he has a liability insurance company which provided him with a legal defense in this matter. I would hope that that would be the case. If for some reason that's not the case, my thinking would be that this whole situation, based on the plaintiff's actions, could open the plaintiffs up for a motion for sanctions under Maryland Rule 1-341. So again, that's Maryland Rule 1-341. And with the same token, I imagine that the plaintiffs in this case had to shell out an enormous amount of money to bring this lawsuit and get this lawsuit to where it came to today. And what? All for nothing. All for nothing. So guys, the legal system is broken.